2798, which concerned two petitions filed by Otter Creek Solar for authorization to construct a 4.9 megawatt solar electric generation facility on Windcrest Road and a 2.2 megawatt solar electric generation facility on Cold River Road. Both projects are in the town of Rutland, Vermont. My name is Margaret Cheney, and with me today is board member Sarah Hoffman. The chair, James Bolts, could not be here today, but he will read the transcript of this pre-hearing conference. And I'll start by taking notice of appearance from the parties.
Sheila Grace for the Department of Public Service. Megan Ludwig for the Department of Public Service.
Don Einhorn for the Agency of Natural Resources.
Melanie Keene for the Agency of Agriculture, Food and Markets.
Dale Azaria.
You have Michael Malone. Michael Malone is on the phone representing the petitioner, Otter Creek Solar.
Dale Azaria for the Division for Historic Preservation. We are not a party yet, but we'll be filing a motion to intervene.
All right, thank you. So I was going to remind you that you will need to file a motion to intervene, so thank you. So the primary purpose of today's pre-hearing conference is to establish the schedule for this proceeding, or these proceedings at this point. Are there proposals for a schedule?
We understood that Mr. Malone had a proposal.
We had shared.
Yes, that's correct. Hi, this is Michael Malone. First, I wanted to thank the board for allowing me to appear by telephone. I understand that's not standard procedure, and I truly appreciate it. I did send out a proposed schedule of various milestones to the department and to A&R last week. My proposed schedule was based on the timelines that GMP was granted in the various GMP solar dockets and the dates in between those various milestones. I have had a chance to speak with the department and with A&R prior to this pre-hearing conference this morning, and their position, and they can certainly interrupt me if I get it wrong, is that they think it's premature to set a schedule prior to the resolution of the joint motion to show cause that they filed yesterday regarding site preparation. So they haven't agreed to my proposed schedule because of that position of theirs.
That's correct. And before we even had filed our motion, we had looked at the schedule that Mr. Malone had provided with us, and our initial response to that was that it was entirely way too compressed for what our needs were from the department's perspective for time, because we are a very full caseload at the moment. But we are primarily, we do think that the board has this joint motion in front of them, and we think it's important that the board resolve that issue before we even propose a schedule for the remainder of the docket.
So you've seen the schedule proposed by Ms. Malone?
Yes, and we do not agree with it.
So there are two issues for the department.
Yes.
In the agency, the same position with the agency. I believe the schedule, because I participated in one of those dockets I think he was referencing, and I think the schedule that was proposed was based on a docket I hadn't participated in, and was certainly appeared to be more expedited than anything I've dealt with. So in that regard alone, it wouldn't be workable. We were happy to work together with the agency and the department to come up with something, but I think that was overcome by events of the motion for order to show cause, which the agency believes, consistent with the department, raises issues that need to be resolved first. And it's not clear to us where that's going to lead, if there's going to be a need for discovery, if there's going to be a need for testimony. And I think, proceeding with that and proceeding with the schedule for the docket proper on the other substantive issues raised in the dockets would, one, be an inefficient use of everyone's time and the board's resources, and it could potentially be cumbersome depending on what issues arise.
And from the petitioner's perspective, we disagree. We don't see the motion to show cause as a gating item in any sense to setting a schedule. From a substantive perspective, with respect to the department's discovery question or the department or A&R's rebuttal testimony, they should be assuming that clearing happens regardless. So it's really a timing issue as to when that clearing may or may not happen. So I think we should just proceed along the normal route of setting a schedule.
Mr. Malone, this is Sarah Hoffman. While we're on the issue, has cutting begun? Has cutting of vegetation begun?
No.
The other issues are whether these two dockets present sufficiently similar questions of law and fact so that they should be consolidated into a single proceeding. And related to that is whether, if they do remain as separate dockets, whether it would be efficient to conduct the proceedings jointly. Is there any comments on that?
Well, from my perspective, it seems like that may be an excellent issue for the parties to brief at an appropriate time in the schedule that's set for the main part of the docket. Just from the department's standpoint, if there are interveners who want to be involved in one of the dockets and don't want to be involved in the other docket, that may help inform how we feel about that consolidation. And from an engineering perspective, I don't know, how our engineering division feels about whether or not they have any separate issues. So I feel like that might be an issue for farther down the line. But I definitely think having any procedures happen jointly will be more efficient.
Attorney Grace, this is Jake Marin, staff attorney for the Public Service Board. Does the department know of any other potential parties that may be joining in these cases?
I do not know at this time.
Any other comments on this issue?
From the agency's perspective, and since we just became aware of this morning and hadn't thought about it before, we've obviously been looking at these as two separate projects, two separate dockets, but it would make sense to have them on a joint track, if you would, and have the same milestones in the schedule. Consolidating it, I have some pause about that, because one of the issues that we are going to want to explore, because of the natures of both of these projects and the clearing of what appear to be mature forest area for placement of solar arrays and related infrastructure, is some sort of a life cycle analysis to see when we may achieve carbon neutrality. And I think the outcomes of that could be very different potentially when you look at just Project A by itself, and that could be very different when you look at Project B by itself, and there could be a whole different scenario when you look at Project A and B together. So to the extent that consolidation might affect that, that could potentially be problematic. We'd have to give that more thought.
Mr. Malone?
Yeah, our position is that the docket should remain separate. Really two individual projects with separate characteristics. So our preference is that they remain separate. However, we do also agree with the other agencies that the milestones should be the same in each.
All right. Another issue is that Mr. Malone, the petitioner, has moved to appear pro se in these proceedings. Are there any comments on that motion?
We have no objections to that request.
The agency has no objection.
Agency of Agriculture has no objection either.
Can I, Mr. Malone, this is Sarah Hoffman from the board. And, you are an attorney, so I'm struggling a little bit to understand why you want to appear pro se, and I think you may have even actually entered a motion to appear. So could you expound on that a bit?
Yeah, I think I am an attorney and an attorney in Vermont, so it would be a motion to appear. I think the motion to appear pro se, that might have been a holdover from a previous project when I was not licensed.
To clarify, Mr. Malone, this is Jake Marin, the staff attorney at the board. Are you withdrawing your motion to appear pro se?
Yeah.
Thank you.
Thank you.
Thank you, that helps clarify that. It's a little unclear whether parties are interested in submitting proposed schedules, but I think that the best course of action would be for the board to issue a pre-hearing conference memorandum about the next steps and address areas of these issues in that memorandum.
And from the agency's perspective, our request would be that the board adopt a schedule for proceeding with the order to show cause at this point.
And the department shares that position.
All right, are there any further comments? Jean?
This is Michael Mullen. Do you want to view a copy of my proposed schedule of the various milestones before you issue the memorandum, or should I wait until after?
It wouldn't hurt for us to see it. So,
Okay, I will send that over today.
and, did you want to?
Mr. Malone, I actually have one other question about the vegetation. You indicate there's no clearing or cutting going on at this point in time. Is that your intention until this case is completed? I think there is something indicating you indicated a desire to clear cut before the case was completed.
Yeah, we will adhere to whatever the board decides with respect to the pending motion to show cause. We'll obviously respond to that motion, and then once the board makes a determination, we have no plans to do anything until the board rules on the matter.
And when you say the matter is the motion to show cause.
Correct.
Thank you.
All right, thank you. Then we will be conferring and issuing a post-conference memorandum. There's nothing else.
I guess if Mr. Malone's submitting some sort of a schedule, again, we're not asking to proceed with the schedule proper, but it's clearly, what he intends to submit is clearly unacceptable to the agency and the department. I don't know if there'd be any benefit added to us submitting a schedule that would be acceptable to us, but again, that kind of ignores the fact that we have an outstanding motion.
I think in general it does help to have proposed schedules from the companies.
We'd certainly be happy to work together and submit one.
That would be difficult, however, because our proposal would depend upon a certain date of a resolution of our motion. And so any dates subsequent to that is something we can't anticipate at this moment, so we wouldn't be able to propose
All right,
exact dates.
then I think it best then for us to do, as I originally suggested, and issue the post-conference memorandum and not receive any further submissions until we've given you all direction.
Thank you.
Well, thank you, we appreciate that.
All right, thank you. And if there's nothing else, then we'll adjourn.
Thank you.
Thank you.
Thank you.
Thank you.